Justice.
Good morning.
Please be seated.
You may call.
Caribbean Court of Justice, Appellate Jurisdiction, on appeal from the Court of Appeal of Guyana. Delivery of judgment in CCJ Civil Appeal GYCV number 14 of 2019 between Chandroutie Persaud, Rafudeen Nizamudin, and Javen Nizamudin. Today's panel comprised their honors Mr. Justice Witt and Mr. Justice Jamadar. Please state your appearances for the court.
Mr. Honors, Chandroutie, I appear with Mr. Chandroutie for the attended appellant.
Yes.
May it please Your Honor, I, Anuradha Deodasi, appear in association with Mohapir Anil Nandlal for the intended respondent.
Thank you. I hope the registry has the names exactly, because it's a little difficult to hear. Yes, thank you. Good morning. The court, which was a bench of 3 judges, myself, Justice Rachnath-Lee, who cannot be here today, and Justice Jamadar, all signed the judgment. Justice Jamadar will give a short summary of the decision.
Yes. In this matter, the original action was brought by the respondent by way of fixed date application under the CPR 2016, seeking the sale of property under the Immovable Property Sale of Interest Act. He asked for an equal share of the proceeds of sale, reflecting his share of the land which he held with the first applicant. Both applicants claimed the property belonged to the first applicant and that she had only included the respondent's name as a trustee for the second applicant. The High Court granted the respondent's application, ordering the sale of the property and the net proceeds be divided equally between the respondent and the first applicant. Both applicants appealed this decision to the Court of Appeal, and the respondent applied to have the appeal dismissed as an abuse of process and for lack of jurisdiction. What the respondent argued was that under Section 62A1 of the Guyana Court of Appeal Act, a final order made in summary proceedings in a civil matter was not appealable to the Court of Appeal, but to the full Court of Guyana. In July 2019, the Court of Appeal, accepting the respondent's submissions, struck out the applicant's appeal for want of jurisdiction. As a consequence, the applicants applied to this court for special leave to appeal the decision of the Court of Appeal to strike out their appeal. This court noted that neither the Court of Appeal Act nor the High Court Act define summary proceedings. The court stated that when the Court of Appeal Act was read as a whole, its purpose and intent is to confer on the Court of Appeal jurisdiction to hear and determine appeals from the High Court and for matters connected therewith. It found that Section 6 created an exclusive civil jurisdiction for the Court of Appeal, and that the plain language of the statute showed that subsection 6(2)(a) created 4 categories of civil proceedings for which the appeals should not lie to the Court of Appeal, summary proceedings being one such category. For the definition of summary proceedings, the court first assessed the meaning of summary. Reference was made to Chung versus AIC, where this court, in interpreting the same section, defined the plain meaning of summary as short, speedy, without delay, or without formality. Secondly, as it concerned the meaning of proceeding, the court rejected the applicant's contention that it was synonymous to judgment. The court also referred to several dictionaries which define summary proceedings as being without customary legal formality. Formal course of legal proceeding is disregarded, without ordinary incidental formalities, and swift and relatively simple. The court further recognized the importance of paying special deference to local courts and referred to Chung versus AIC, in which the Court of Appeal of Guyana found summary proceedings to be an abridgment of a trial in which the established form of legal proceeding is not adhered to. As evidence of customary practice in Guyana, the court noted that the legal tradition over the last 40 to 50 years showed appeals in similar actions being made to the full court. Based on these points, the court found that summary proceedings under Section 62A1 had two main features: being short, speedy, without delay or formality, and its process not following that of a full trial or regular common law process. This court, therefore, agrees with the Court of Appeal that the combined effect of the provisions leads to the inevitable conclusion that appeals against orders made under Order 12 of the rules of the court should lie to the full court. The court then assessed the effect of the CPR 2016, and having considered that, the court found that matters which could be dealt with expeditiously, such as fixed date applications, were summary proceedings, and if taken on appeal to the full court, could be dealt with in a timely manner as opposed to the Court of Appeal. In the court's view, bearing in mind all of the considerations already stated, the application for special leave was refused. The action commenced by the respondent on the 16th of April 2018 was decided on the 12th of June 2018 in a relatively swift and simple manner with no need for a full trial. For the purposes of Section 62A1 of the Court of Appeal Act of Guyana, the incident proceedings were found to be summary proceedings, and therefore the full court of the High Court was the proper place for the appeal. Therefore, the Court of Appeal of Guyana was correct in striking out the applicant's appeal for lack of jurisdiction. In these circumstances, the application for special leave in this case had to be refused. In these circumstances, the court made the following orders: A, the application for special leave is dismissed, and B, that the applicant shall pay the respondent basic costs in the sum of $179,500. I should add that this summary is not intended to be a substitute for the reasons of this court, or to be used in any later consideration of the court's reasons.
Thank you, Justice Javen. I think, Mr. Rafudeen, you have joined us in the meantime.
Good morning, guys. I'm very sorry.
Yeah,
We
well,
are in interesting.
although we have
interesting times.
Although we understand the difficulties that traffic can sometimes cause, we still like to be on time. So, and as your junior was already in court, we thought it would be proper to start at the time, the given time.
My senior, Your Honor.
Okay, Mr. Rafudeen and ladies, if there is nothing else, then this is the decision. I hope you already have it in writing.
We do, Your Honor.
Okay, great. Then this would be it for today.
Thank you so much, Your Honor.